Hi everyone, welcome back to Litigation Help. My name is Hui-Litwin, and today we're going to talk about an upcoming hearing at the Supreme Court of Canada that's generated a lot of buzz lately. In fact, in addition to the parties, there are 17 interveners for this case. So the case is called Ahluwalia versus Ahluwalia, and the issue is whether the law should recognize a new tort for family violence. In other words, should a person be allowed to sue for damages for domestic or family violence in a family court proceeding? Now, you might ask, what? Like, can't you already sue for that already in our current system? Like, what's the big deal? What's the significance? So joining me here today are regular guests, Laura Tarcea and Eva DiGiammarino, both from the Family Mediation Group. Hi.
Hi, nice
Hi.
to nice to be here again.
Yes.
Thank you so much for coming. So Eva, maybe
Mhm.
if I can ask you to start us off first in this discussion, can you tell us a little bit, sort of briefly, about what the case is about?
Sure. So I'm going to keep it really brief because there are a lot of facts. It is a heavy fact scenario, but
Right.
the main facts that are important for our purposes, just so everybody has an understanding of what happened. Basically, it's a family law case. And as many people may know, when a family is getting separated or divorced, one route for them to take is to go to court to settle their dispute. That's not the only route, but it's one route. That's what this family did. So this family went to court to resolve the typical legal issues in any family separation, how they divide their property, the support of their children, etc. Now, in this family, they were married about 16 years, a little bit more. They married in 1999. They separated in 2016. They had two children. When they were in court talking about the division of assets and debts, child support, spousal support, the wife also brought a case asking for damages on the basis that she experienced physical, emotional, and financial abuse. Now, the reason, and we're going to get into this in a bigger way, the reason why that is significant is a couple of reasons. Number one, she was self-represented. So that's something that we should keep in mind.
Mm.
So she was self-represented, and so she thought, like any normal person would, that they could ask for these damages in family court. She was already there. She was already in front of a judge. So she brought up the evidence of abuse and asked to be paid, right,
Mhm.
for her experience. What's novel about that is that technically that request for damages for assault, abuse is a different court system. It's a civil court. And so the judge in this case had to handle, does she address this woman, this applicant's request for damages here? Does she dismiss it and tell her to go to another court system, etc.? So that's really what it centers on is the damages for abuse, how to ask for them and where to ask for them, what court system.
So that's right, because family courts usually just hear things like divorce, spousal support,
Yep.
property division, and in this case, she's actually asking for damage. Now, just for those who are unfamiliar with the term damages, what is
Right.
that? What is that in plain English?
Right. So when a wrong has happened to somebody,
Mhm.
right? Um, the justice system can compensate you for that wrong financially, right?
Right.
And so there's two elements or ways that someone can be compensated financially. So the compensation generally, we refer to it as damages.
Got it.
Okay.
Okay.
There are two elements. There are compensatory damages, usually damages that are meant to make someone whole because they may have lost financially because of their wrong.
Mhm.
And then there are punitive damages to say your behavior was so, mean or bad that I deserve this money because of what you put me through. So you don't actually have to show a loss. So that's what we refer to when we say damages is the financial compensation, quote unquote, that a court awards because someone has been wronged.
So what is the outcome in the trial decision?
Yeah. So in this trial decision, the judge agreed that this wife should successfully, so she actually, let me start from the beginning. The judge acknowledged the evidence of abuse. So the judge found that not only were there at least three specific instances of physical abuse
Mhm.
where the husband attacked the wife, but over the 16 years, from the early marriage to the date of separation, 16, 17 years, there was a pattern of physical, emotional, and financial abuse.
Mm.
There was elements of coercive control. These are all important terms that the judge used. And for that pattern of abuse, the wife was awarded $100,000 in compensatory damages
Mhm.
and $50,000 in punitive damages. So 150. And what's important to know is this has nothing to do with what the wife or the husband is entitled to for spousal support, child support, dividing the assets. It's all separate. That just has to do with the abuse.
Oh, wow. So this is almost like in addition to all these
It
other
is.
claims about
Yeah.
this, there's so then I guess the husband was not happy
Yes.
with the with the trial decision.
Husband was not happy.
Right. So then he went to the Court of Appeal, and what happened at the court?
And if I may,
Yeah, sure.
and this is just my complete opinion,
Okay.
okay? Of course, the husband was probably not happy with the ruling. I
Yes.
think his lawyer
Yeah.
was probably also not happy with the
Right.
ruling because this was
Right.
a self-rep,
Oh,
right?
yeah.
Who on her
Even
own
worse.
created a case with
Yes.
the judge was certainly very open to working with a self-rep. Not every judge is, but
Yes.
here
Yes.
a self-rep and the judge created new law. And
Yes.
so
Yes.
any lawyer representing the husband is likely going to appeal because when new law is made,
Yeah.
lawyers always have something to say about it, right? It never pleases everybody
Mhm.
at the first instance.
Right.
So they appealed to the Court of Appeal.
Right.
Court of Appeal said that what the judge did, and we're getting into kind of the granular analysis here, but what the judge did was identify a new category of law that someone can sue another person for. The judge identified the category that they called the tort of family violence.
Yes.
Okay.
Mhm.
And what's distinct about what the judge created was number one, there doesn't have to be specific instances of physical assault for someone to sue for this quote unquote wrong. It's
Mhm.
what we call a tort, but we can
Mhm.
even just call it a wrong, right?
Mhm.
So there doesn't have to be a specific physical altercation. Number two, it can be any family member. So it doesn't have to be between spouses. Okay.
Mhm.
Um, so in the trial judge creating this wrong and saying, yes, this wife is talking about the tort of family violence, which is not just physical instances of abuse, but a pattern of coercive control, financial abuse, emotional abuse, etc. Her creating it, the Court of Appeal said she went beyond her judge's powers
Mhm.
and that the law already is sufficient. The Court of Appeal said the law already has avenues for someone who has experienced that type of abuse to obtain damages. And the Court of Appeal went on to say that they felt that the judge in creating this new category may be confusing the law and also possibly making the court system um, more complicated
Even
and
more
oppressive.
complicated. Right.
Yes. And so they kind of dialed her back to say there are already categories
Right.
for this woman to um, to launch her complaint. She doesn't have to do it in family court under the heading of family violence. They also reduced the damages. So instead of her receiving 150, she received 50,000. And again, it's granular. But why they did that was because they said, and this is settled law, when a judge is going through punitive damages, they have to be very specific about why the damages are punitive.
Mhm.
And they said that the judge wasn't specific enough.
I thought the trial judge was pretty specific.
I thought she was very specific. So,
Yeah.
no. So they reduced the award. So now the wife is appealing, right, to the Supreme Court of Canada.
Now, when the Court of Appeal said, well, the wife had other ways, I mean, just the existing system has other ways to deal with this wrong, they must be referring to the civil system like you mentioned, aren't
Yes.
they? So it
Yes.
would mean that if so currently, the way it is that if you want to sue for damages, you would have to not only have a case in family court, you have to have
Yeah.
another, run a parallel case at the
Yeah.
civil
That's
side.
exactly it. That's
So it's
exactly it.
expensive. It's very
It's
expensive. You cannot even
very
afford a
expensive.
case in one court, let alone two courts.
That's exactly it. And for jurisdictions, so some jurisdictions in Ontario,
Yeah,
the family court and the civil court are in the same building. They're in the
right,
same courthouse. They're in the same courtroom,
right,
right? So
right,
that makes it a little bit easier.
right.
Some jurisdictions, like for example, Newmarket, Ontario,
Yeah.
Newmarket has its own space for family court. But
Uh-huh.
what that means is if you have a family court case, you have to walk across the street for your civil case. Right. So it really doesn't, and it sounds kind of silly, but it means there's separate filings. You need separate lawyers. It can get very convoluted.
Oh
Uh,
my goodness.
yeah.
So you probably maybe even need to get, well, if you're not self-represented, you have to get two different lawyers. Like one is a
You
civil,
could, unless your family lawyer
unless
feels
they know both.
comfortable to do it, but not every family lawyer feels comfortable to engage in a civil tort action, which is what we're talking about here.
Yeah, I
Not a
mean, just
civil.
even looking at the forms you fill out, it's like the family system is completely different
Right.
and
Yep.
separate from the
Completely
civil
different.
system.
That's right. Completely separate forms,
Completely
completely
separate.
separate laws.
Different
Absolutely.
seven, different rules of procedure.
Yep, absolutely.
So so it's almost like having to learn two languages, two sets of
Absolutely.
legalese
Right.
if you want to
Yep.
handle it yourself. That's what that
Right.
means. Okay,
Right.
I'm wandering off into opinion territory here, so I better just kind of like stop right there. Okay, so now the issue is gone to Supreme Court of Canada, and I just want to just stop here for a moment to remind people, to remind everyone that you can watch the hearing, and it's going to be February 11th to 12th at 9:30 in the morning. And you can just go to the website, and I'm going to provide a link as well in the description box so that you can just hit the link and go there directly, and you can watch the hearing live. They also have the materials like the factums and so on the website. So if you want to read about it beforehand, that might help you. If you like, for geeks like me, I like to read the stuff, but yeah, so it is there for you if you like to watch it. Okay, so I just have a few more questions before I head to. I have a question about family violence because when I first read this case, I thought, oh, it sounds like it's a sexual assault or it's a battery, but you're saying it's more than that. It includes a
Yeah.
broader basket of
Yeah.
wrongs.
Right. This case, this judge, in my opinion, does a great job, the trial judge, of acknowledging that family violence is
Yeah.
not just physical violence. And even though, people may hear that and say, of course, like, we all know that, studies and understanding of domestic violence and intimate partner violence has come very far. The justice system can sometimes still be behind, right? It's much more common as someone who works with individuals who are in and out of the justice system, it's much more common for the justice system to focus and be attracted to physical elements of violence as opposed to what they would maybe assume or consider are less significant experiences of quote unquote violence, emotional, psychological, financial. But we see that all the time, right? Even in the criminal justice side, it's very common that, a murder is taken seriously, or maybe more seriously than if someone steals, $10,000, or if someone breaks into somebody's home, right?
Hmm.
So we see that, it's still embedded in our family court system that physical violence tends to quote unquote trump or be taken a little bit more seriously than the other elements. But what the trial judge does acknowledge is those other elements, the psychological abuse, the financial abuse, the coercive control, is so significantly impactful that it has to be recognized as a form of violence in and of itself that can lead to um, compensation
Well,
for
I
the
suppose the
support.
Court of Appeal might say, well, but you have this tort of intentional, that big
Right.
long name. Yeah, that
Yes,
intentional
intentional infliction of
emotional
emotional.
suffering. But that's still at the civil side only, right?
That's
That's
right.
You can only access that through the civil court.
That's right. And a lot of the interveners that are going to intervene on behalf or similar cases to the wife's side
Hmm.
are going to argue that the civil system still has definitions and thresholds and tests that are very difficult for a survivor of domestic violence to meet, especially if, if there's only been three physical altercations. Someone may say, well, there was only three physical altercations, so
Hmm.
we're going to determine your what you should be compensated by on just those three events. That's a lot different than saying, hey, we acknowledge that you lived for 16 years in an environment where you couldn't say your opinion safely, you couldn't have access to money,
Hmm.
you couldn't, your autonomy was significantly reduced, right?
Hmm.
Like there's a lot more acknowledgement in the totality of the experience than just looking at isolated events of assault. And that's one of the criticisms is the civil side will may do that more than what the
Hmm.
trial judge is suggesting the approach should be on the family side, is looking at the experience as a whole and understanding the impact that that experience has had on the person, and then determining what should be the resolution after that.
I have a question. Why can't, in the family court side, why can't a family court judge simply just award a higher amount of spousal support or an equal family property division in recognition of this pattern of
Mhm,
abuse? Is
mhm.
it possible?
So there are conversations that can be had under the guise of spousal support. However, generally, you know, the law likes, if you think about it like streets, I kind of think about it like avenues. The
Okay.
law likes really clear avenues.
Mhm.
And just because it's easy to understand and it's easy to kind of train the lawyers and everybody in the system on the avenue,
Mm.
right? And that's where I think people are getting tripped up and the different courts are coming up with different opinions on this case. When we are it's sometimes considered mixing the avenue. So there's already an established law about how to determine spousal support. Adding in the element of abuse, it would be seem to be considered like mixing the avenues together. Now, spousal support's tricky because that one is more broader, and I have seen conversations or mentions of abuse under that guise where it could be slightly more tolerated, but nowhere near the amount of what we're talking about here. The division of assets is very, very clear. Laura and I tell our clients all the time, it's just a numbers game. It has
Mm.
nothing to do with any emotional elements. And I understand why proponents of that system want to keep it that way.
Mm.
Family law is very messy, it's very emotional. And the professionals in the system have done a very good job or have tried to create the law to put those emotions aside, right? And so when we have people all the time coming to us in our practice saying, "Well, I should get more than 50% of that bank account
Right,
because
right,
of how this person treated me."
right,
And
right.
we say, "No, that's not how this works. The money and the division of assets has nothing to do with the emotional treatment you've experienced. Because if we were to include that, the concern is nothing will ever get resolved,
Yeah.
right? A part of this has to be, um, a part of the analysis of family law has to follow a logical analysis that is less emotional in nature. And so I think for those reasons, that's why we have right now a system uh, with pros and cons, of course, but that
Hmm.
has the assessment of family violence as a separate entity.
Interesting.
Yeah.
I find that very interesting. I only now that you're explaining this, I'm getting it that there's that tension
Mhm.
between keeping a family case civilized, I guess.
Right, right,
Yeah, and they did that intentionally, and now it seems like it's like going the opposite direction because when you're going to create this family tort, you're actually almost like introducing the fault back into
right.
the system, and it just gets ugly. Well,
So that's a big argument that the husband's side and his counsel are
yeah,
making, is
right.
that if we're trying to move away or shift,
Yeah,
an adversarial system,
right.
then what one argument they're making is that this big tort of family law, of family violence,
Yeah,
means that, technically there can be it can make the any case much more adversarial and much more litigious.
right.
Especially, they do have a specific argument that I acknowledge. I don't think it's that necessarily a bad one, but my opinion is my opinion.
Right.
Their argument is that so the trial judge created this tort of family violence,
Yeah,
which she acknowledges that doesn't have to be between spouses. So,
right.
but then what the husband's counsel is saying is arguing is that means that there could be many cases where if one person is saying they experienced abuse, the children could sue. The children could be added as
Mm.
parties to the
Yeah.
agreement to sue the parent because they witnessed the abuse, right?
Hmm.
Or if your in-laws were physically or emotionally or verbally abusive, you technically could sue under this tort.
Wow.
So what they're saying is, and the husband had said, listen, in this case, they were separated in 2016 and it's 2025
Yeah.
and they still haven't figured it out, right? We don't want families to be bogged down in the complexity of this case. That being said, my perspective is
Hmm.
lawyers are very smart, judges are very smart.
Hmm.
I think we can figure out the law and
Hmm.
streamline it so that it doesn't have to get adversarial, doesn't have to be in the court system. I know Laura's going to talk about, the mediation process,
Hmm.
but where domestic violence can still be appropriately addressed and acknowledged. I don't think that the answer to saying, well, yes, the system doesn't acknowledge domestic violence sufficiently, but we don't want to address it sufficiently because we don't want to make it complex or adversarial. I don't think that's good enough. If if right now the main issues with domestic violence are being experienced by the survivors of domestic violence, and then those survivors turn to our court system, and our court system says, well, we'd love to help you, but it's just too complicated. And we don't want to engage in something adversarial and messy. I don't think that's good enough,
Mm.
right? We should just figure out the messy.
Yeah, I agree.
I'm hoping that the Supreme
Yeah.
Court sees that, right?
Yeah.
Who cares if it's going to be complex? Who cares if it's going to be complicated? Let's use the tools that we have as a justice system to figure that out, because the most important thing is that intimate partner violence, family violence, whatever you want to call it,
Yeah.
is acknowledged and appropriately uh,
Okay.
compensated for and
Hmm.
is a deterrent,
Yeah.
right? That's a part of punitive damages that is so important, that
Hmm.
it should deter. So people should read this case, right? The trial judge,
Yeah.
that's part of what they did, right? They wanted people to read this case to say, hey, now if your
Yeah.
trial sues you for domestic violence, you may have to pay another 150,000.
That's what the
That may be,
consequences.
yeah, that is
Yeah.
an actual consequence that's in the social lexicon that is important, right?
Just a couple of practical questions, and we're going to move on to the mediation side. Um, so now everything is up in the air. So would you say to someone who is in the family system right now, or who is thinking about starting a case, should they include the tort claim in the statement of claim? Like, should they include it just in case?
Yeah, I would say yes,
Oh,
they
okay.
should. I would say, and I know, this video is geared to self-reps.
Yeah.
I would strongly suggest that the self-rep tries their very best to get even unbundled legal services,
Right.
some helping hand
Yeah.
from someone with a legal background, even if it's you know, I think Osgood has like a legal clinic, right? Even if it's a legal clinic with some students, just because it right now it's so complex that
Hmm.
even a lot of lawyers don't know how to make this case. But yes, you should always, like this woman did, right? She brought her concern to court. The courts, the worst thing they could do is just say no and dismiss a claim,
True. That's right. Yeah.
right?
It's
So
better
for
to,
now,
yeah,
I
just in
would
case.
never dissuade someone from bringing the claim, but I would have the caveat that it's very difficult to do successfully alone.
Right, right. I agree. And I'm going to put some links to some resources for
Mhm.
self-reps in the description box. I don't know if I even want to ask this question because maybe it's just too much. Like, how does somebody know how much to ask in terms of the quantum, in terms of the damages? I mean, I know that in Canada you don't just go, oh, $1 million, but
That's
it
right.
has to be some basis. Do you have any suggestions of how somebody would kind of come up with the calculation as to figure out how much roughly should I sue for?
So on the civil side, it's a little easier. On the family side, we just don't have that many cases.
Right.
But generally, what would happen is a person would hire a lawyer. The lawyer would call their junior lawyer or student into the office, and they would say, "Okay, so and so is suing for, intimate partner violence, and they
Yeah.
want damages."
Right.
Research
Yeah.
the last cases in the last 5 years,
Yeah.
right? To determine on a similar factual basis, right,
Yeah.
what has been awarded. So right now we have a case on the record, right? Ontario Court of Appeal
Right.
said 16 years of this abuse that this woman experienced, and they awarded her 50,000, right? So someone who's going to say, well, I have 3 years, they're likely going to get a lawyer to say, well, this woman had 16,
Hmm.
right? And she got 50. So that's exactly what they would do. Again, it's a little harder for the self-rep, but not impossible. There are free, which I'm sure you're going to have on your website, there are free resources where they can research themselves. But
Right.
that's what you'd be looking for is historically what has been awarded.
Right. Again, that principle of precedent.
Right, exactly.
That's just what we're based on.